بسم الله الرحمن الرحيم.
Bismillah, alhamdulillah, wa salatu wassalamu ala rasulillah. So today we want to talk about some case law examples, actual court cases from the corpus of Islamic law. Before we do that though, there are a few ground rules that we want to set, and we're going to build on what we talked about yesterday with the maqasid al-sharia, or the objectives of Islamic law. Yesterday we talked about the objectives of Islamic law, attempting to preserve faith, life, honor, family, mental health. And today we're going to see how in individual cases those precepts are used in conjunction with what we usually know about fiqh or Islamic law. And we're also going to look at some instances of the process of Islamic law. Because yesterday, I believe in the Mardiya show, we talked about how there's this concept that there's only an austere, very dogmatic application of rules and no nuance. So today we're going to see some of that nuance. So Sharia is not synonymous with Islamic law, and we talked about that yesterday. Sharia is the general precepts, principles, doctrines, whereas fiqh is the individual application of that law in a specific context. Also, it's a human endeavor. So the mufti, the faqih, the qadi is an individual. He's a human being. He is prone to error, and he may make mistakes, which is why the Prophet ﷺ said, إِذَا حَكَمَ الْحَاكِمْ فَأَصَابَ فَلَهُ أَجْرًا وَإِنْ حَكَمَ وَلَمْ يُصِبْ فَلَهُ أَجْرٌ وَاحِدٌ أَوْ كَمَا قَالَ صَلَى اللَّهُ عَلَيْهِ وَسَلَّمَ. When a ruler, a judge, or a mediator rules and he's correct, he gets 2 rewards, and if he is incorrect, then he gets 1. Now we talked about the theological, substantive, and ethical principles of the Sharia that remain the same, but our Islamic law is subject to time, place, and extenuating circumstance. So in an individual case, while ruling may be X in the Sharia, then its application in fiqh may be different. Now, when we talk about fiqh, we're generally talking about the general understanding of the scholars of Islam. And this has been compiled into compendiums. And in other legal systems, this might be similar to what we call the black letter of law. And it can differ between venue and jurisdiction. So now in our Islamic tradition, we have different madhahib. And those madhahib generally were more fluid, and they weren't set in strict regional jurisdictions as we have nowadays. But you can understand that somebody might go to the qadi of the Shafi'iyya on a certain issue, and there might be a qadi of the Hanafiyya at the same time. And there were few qudat in the history of Islam who actually were qualified in all 4 madhahib and would give fatwa and rule according to those madhahib. Excuse me. Now, each and every attempt by a mufti, a faqih, a qadi, so a mufti, one who issues religious edicts, a faqih, a jurist, a qadi, a judge, or a mediator, or an arbitrator, a muhakkim, they are all attempting to approximate what Allah and His Messenger want from us in that particular instance. And because of that, they have discretion on how the law is applied to a certain extent. Now, I want to draw your attention to this slide right here, because this has actually come up in the news recently. There was an interview on CNN between an individual who is a political commentator on TV, Kaylee something, I'm forgetting her last name right now, and Reza Aslan. And she claimed that there is academic proof that over 85% of the Quran has to do with legalities and has to do with a legal system. And this is an attempt by detractors of Islam to strip the Muslim community of their religious identity and pin them with a political identity so as to deny them the freedom of religion in the United States. So be very, very careful about what you hear about these issues. I bring this up to say if you look at the Quran and take all of the different verses of the Quran, okay, the 6,000 some verses of the Quran, 22% of the verses of the Quran deal with issues of Iman and Aqidah. About 14% of it talk about the concept of ummah, community, and what it means to be a congregation and the principles of that. Then there are issues of akhlaq, character, about 13% of the verses of the Quran. Then there's al-qasas, stories that are in the Quran. This is about 11% of the Quran. Pedagogy, and how one teaches and educates. It's about 11% of the Quran. There are issues of admonition, which are about the same, right? Wa'adh, things that exhort us to do something or admonish us and tell us to stay away from something. There's issues of affirmation. Affirmation here, affirmation of the next life, telling us about the unseen. Then, when we get to issues of law, there's only 7% of the Quran actually deals with law, deals with what we would consider to be law. Even less than that is 0.609% that uses the word qital, fighting. Even less than that is 0.417% that uses the word jihad, and amongst those, only, or I would say about 1/3 of it is actually talking about ideological arguments and not something which is a physical altercation. And then 0.096% uses the word nafir, and that is the idea of deployment or deployment of troops by a sovereign state. So the idea that the Sharia is somehow, or that the Quran is somehow completely focused around legalities and animosity through those legalities to other people is just patently false. So the Quran, is it the literal word of God? This is something that we hear. I prefer to say that it is the immutable word of God, meaning that the text of the Quran does not change and we read it as it has reached us from the Prophet ﷺ, but the meanings of the Quran are interpretive, and therefore a single verse can have more than one meaning. And then here are two things that we do when we want to go from the text of the Quran to the context. We have to look at several factors. We have to, number one, look at the historical context, the theological context, the cultural context, and the literary context. And what do I mean by this? So for example, Allah subhanahu wa ta'ala says in Surah Al-Baqarah, وَلَا تَكُنْ كَالَّتِي نَقَضَتْ غَزْلَهَا مِنْ بَعْدِ قُوَّةٍ أَنْكَاثًا. Most of us will read this verse and have no idea what it's talking about. And do not be like the woman who, after spinning her yarn, then picked it apart. And none of us have any idea what spinning yarn is and what the process is, unless, of course, you're familiar with that children's story. What is it? Not Rapunzel. The other one? Rumpelstiltskin. Okay? That's the only instance in my entire life that I remember somebody spinning yarn. Okay? She was told to spin the hay into gold. So this is a metaphor that's used in the Quran, which was very relevant to the Arabs at that time in their cultural and historic contexts, saying, don't do something, put it together, and then break it apart, thinking that you're doing good, right? So don't come into faith, and then pick it apart, thinking that you're doing good. For kids, don't build, a galactic starship out of, Legos, Star Wars Legos, and then as soon as you finish building the whole thing, you smash it with a bat, right? That would be completely counterproductive. That can only be understood, however, when we read the Quran in its cultural and historic context. So we have three levels of understanding of the texts, whether they be the Quranic texts, the text of the Sunnah, the text of the scholars that are found in Islamic law. And that is the layman's understanding, which each and every one of us can understand. Then, what Sheikh Sa'ad was talking about, the learner's understanding. Those of us who are still learning, we understand what the meaning is, and then we have the expert understanding who understands why it's meaningful. Kind of similar to what we were talking about yesterday between what something means, when it has meaning, and when it is meaningful. Now, when we look at the entirety of Islamic law, and I know that there's a lot to unpack here. When we look at the corpus of Islamic law, we can see that in general it's divided up according to this pie chart. 65% of what you will find in any book of fiqh is not considered law in the Western legal sense, right? It's not considered in common law and civil law and Chinese law, anything like that. It's not considered law. It's considered custom. It's considered convention. It's considered culture. But it's not considered law. But for us as Muslims, fiqh dictates to us how we purify ourselves, how we pray, how we fast, how we make pilgrimage, the food and drink, what is halal and what is not, how we make vows and oaths and things that we take upon ourselves. When we look to the other forms of Islamic law, 20% of Islamic law, legal compendiums, books of fiqh, deal with contracts, partnerships, endowments, and similar transactive issues. Then we got about 10% of Islamic law that deals with probate. Probate is the law of inheritance, okay, and how your estate is divided up, right? So al-fara'id or at-tarika, as they say in Arabic. And then you got marriage and divorce and custody. 5% of this deals with adjudication, the law of the courts, a judge making a decision about how to implement the law. Penal code, sentencing, punishments, and then international relations, how states, countries deal with each other. So notice, when we talk about the verses of the Quran and the context of fiqh, they're very, very similar in the amount that they actually, where they line up on these percentages. Next slide. Looks like we're, okay. Sorry, I had some animation in there that I can't see because of the light here. Now, I don't know if you can see it, but if you look to the side here on the right in red, unfortunately it didn't come out as well on the screen, all of these issues, the 65% of these issues are non-judicable issues. What do we mean by non-judicable issues? They are issues that cannot be decided at court. Meaning that if you choose to not fast a day in Ramadan, no one can take you to court for not fasting a day in Ramadan. If you miss a prayer, no one can say State versus Joe Bradford for not praying Dhuhr Salah. Okay? That's not going to happen. By the way, it's Joe, never Joseph. So, sad to make that correction. However, if you look at the other areas that are here, 20, 10, 5, okay, the 35% that we have over here, these are judicable issues. These are issues in which there is some procedure or process and that they can be taken to court. For example, if you have a dispute between two people that are contracting with each other, they can go to court. If you have money that was placed into an endowment and inheritors have a claim on that money, they can take that to court. If you are in a marriage and there is some form of abuse or misappropriation of wealth or denial of rights, that can be taken to court. And even if you have the state making decisions which affects the Muslim public, the state itself can be taken to court. So the ruler of a sovereign Islamic land can be taken to the court because the courts in Islamic law are independent of the ruler. Now, there's a concept of man's rights versus God's rights before we go forward, before we look at the actual cases. And generally they line up with common law in that man's rights are similar to private rights and God's rights are similar to public rights. So they say, حقوق wa وحقوق العباد. Anytime there's a private right and there's an offense against them, you have the ability to adjudicate that, you have the ability to litigate that in court, take someone to court, okay? And there might be implied sentencing and implementation. When we talk about criminal punishments as a public right, this is solely vested in the state. And this is only for a sovereign Islamic government to make decisions on. Now, it's also referred to in the Quran and the Hadith as hududullah, the boundaries set by Allah. And I want to draw your attention to something very important. When we talk about, although there's a lot that's said about Islam being barbaric, or Islamic law, or Sharia law, okay, all this fear-mongering. So we have two things actually. We have fear-mongering from non-Muslims about the implementation of Islamic law and the practice of Islam, okay? And then we have takfir mongering, okay? This is a friend of mine coined this term. We have takfir mongering and we have fear-mongering. Fear-mongering are people from outside of the community saying you people are just unbearable, and we shouldn't be trying to implement anything of Islam. And then takfir-mongering are people in the Muslim community saying you people are terrible, and we should not be trying to implement anything of Islam. Because when you say that that's wrong, they say, why are you doing takfir me, bro? Don't takfir me, right? So this idea of political takfir, when you differ with them on political issues, because of their lack of sophistication and knowledge of these issues, they will throw that out for anyone practicing their faith as somehow excommunicating anyone that disagrees with them. It's a very dangerous concept, and it needs to be reined in because people are using it and stigmatizing large swaths of our community. So there should be no stigma, no blame for anybody that wants to follow a more conservative opinion in our community. That has to be done away with. So the punishments that are laid out in the Quran and the Sunnah that are implemented in Islamic law, that are executed and applied by Islamic courts and the subsequent government agencies that follow them are actually very few. They're only about 7 in number. Now compare that to the common law system when in England you had, for example, 200 punishable offenses that were capital punishment offenses on the books until the late 1900s. So you only have 7 in the Quran. Also, the evidentiary standards for these 7 are extremely high. So the idea of adultery or fornication, there has not been a single instance in the history of Islamic law where 4 witnesses has come forward and actually met all of the stipulations for that ruling to be applied to them. If it has ever been applied, it's because the person, out of their sense of guilt, said, I am guilty and I want to be sentenced for this sin because I hope to be expiated and cleansed and absolved of that sin in this world. Okay? So that's a very important distinction. Now, there are a lot of popular assumptions about Islamic law, and we're going to cover these, which is 7 cases today. Okay? We've got 23 minutes. I hope that we can get it done, inshallah ta'ala. Right? So we're going to cover these 7 cases. Spousal abuse. There's an idea that it de facto permitted by Islam, right? Women's inheritance. The women always take less. Female genital mutilation. This is something encouraged, if not obliged. Public intoxication. Every time the person must be flogged. Adultery is stoning. Theft is amputation. Slavery is a preferred status. These are all assumptions that people make about Islamic law. Both Muslims and non-Muslims make these assumptions based upon a very limited reading of the sacred texts of Islam and a very limited knowledge of the heritage of Islamic law. So, more animation to get through. So, let's take this case right here about theft. And what I've done is I've tried to list each case, talk about its salient points, as one would read regular case law summary. So Muslim citizen versus the Second Caliphate. This is recorded in the Muwatta of Imam Malik. A farmhand is caught stealing a camel. When interrogated, he admits and he is sentenced to having his hand cut off. This is the case. Guy working on a farm steals a camel. Why? He's going to go and sell the camel. He's sentenced to having his hand cut off. Now, after being presented for sentencing, the farmhand, he says, yes, I did steal. But the reason why I stole is because the person who hired me on the farm would not pay me my wages, and I was unable to eat and feed my family. When the employer is brought to court at sentencing to confirm the facts which were left out of the original case, he admits, yes, I haven't paid him. So the rule of law is that the principle of duress, of ikrah, is that it absolves one of legal responsibility. So in the Quran, Surah Al-Baqarah, verse 173, so whoever is coerced, seeking not transgression, غَيْرَ بَاغٍ وَلَا عَادٍ عَلَيْهِ, to transgress or infringe, then there's no sin upon him. So the accused person's admission of guilt that he stole a camel is vacated, and he's not sentenced because it was due to him being coerced or in a state of duress, where he had no other choice in life except to steal something to be able to feed himself and his family. And this absolves him of that. And so the holding was, and this is what Umar ibn al-Khattab radiallahu ta'ala anhu ruled in this case, that the punishment was mitigated from the person that was originally accused. And the person who denied him his wages, his employer, was fined double the cost of the camel as punitive damages. So not only was he absolved of this, and this punishment not applied to him, but he was given by his employer double the cost of what he stole, even though what he stole might have been well above the wages that he earned, as punishment to the employer for denying someone their right as an employee. Case of female genital mutilation. Wife versus husband. And this happened between the years of 656 to 661 during the Khilafah of Ali ibn Abi Talib radiyallahu ta'ala anhu. And it's mentioned in Al-Kafi and mentioned in Al-Turuq al-Hukmiyah. So a woman presents herself against her husband claiming bodily harm. When it's investigated, it is found out that he had actually taken and mutilated her vagina, mutilated her private parts. And so, because of this, the rule of law is that anytime there is some form of bodily harm, it's a criminal act. And there are compensatory damages that are due at minimum. Now, the general rule for bodily harm is that if you deny somebody a faculty which is essential to their quality of life, it is as if you have killed them. So for example, in this case, right, here the reasoning is any bodily part of which there is only one and is essential for personal benefit is awarded compensatory damages equal to involuntary manslaughter. So it is almost as if you have killed a person when you take off when you deny them a faculty of which they only have one. So let's say, for example, someone cut out someone's tongue. This would be equal to killing them. You've denied them the sense of taste, the ability to speak. If you cut off their nose, right? When you've done something like this, it's as if you have killed them. And so there's also, in addition to this, a form of discretionary sentencing which the judge can apply due to the malicious nature of the act. And so what did Ali radiallahu ta'ala anhu rule in this case? He not only said that this husband had to pay compensatory damages equal to involuntary manslaughter, okay, which would have been the diya, right, diyat al-qatl, right, the blood wit for killing, which is about, how much is the diya? 100 camels. Okay, 100 camels nowadays, it'd be like 100 Bentleys. Okay, because not everybody had camels. Camels and gold were only owned by the very upper crust of society at the time of the Prophet ﷺ. Okay, so he not only owed her the compensatory damages equal to involuntary manslaughter, but also he had to pay her. He had to support her financially until she died. So the first was because of his mutilation of her. The second was as an extra discretionary ruling to deter him and anyone else that would ever think of doing that again. So he not only owed her the compensatory damages equal to involuntary manslaughter, but also he had to pay her, he had to support her financially until she died. So the first was because of his mutilation of her. The second was as an extra discretionary ruling to deter him and anyone else that would ever think of doing that again. So the idea that somehow female genital mutilation is encouraged or supported by the Sharia is patently false just from our reading of Islamic history. Falsified emancipation. This is a very interesting case. It happened during the Ottoman era. A slave comes to a judge and he says, I have proof that I am free. And he presents documentation to the judge, and the judge says, based on this documentation, you are free. I have freed you in the name of the state based upon this documentation. He accepted it as relevant and applicable, and therefore this man was freed. Now later on, this man who was a slave and was then freed, somebody asks him, where did you get this documentation from? What did you tell the judge? He's completely made it up. I lied. I actually was a slave, but I just wanted my freedom. Now what happens? What happens is he is not returned to slavery. Why? As al-Bazzazi al-Kurdi, he says in this case, because the Sharia seeks emancipation as an objective. It seeks freedom. الشرع يتشوف إلى الحرية, as Tahir ibn Ashur says. The Sharia in and of itself, its precepts and doctrines, looks for freedom for people. So it would be oppression to take this person and return them to a state of slavery. So therefore, even though the documentation was false, the ruling of the judge, okay, the declaratory judgment of the judge is implemented and is not reversed. What does that mean? That means that the judge, acting on behalf of the state, right, has made the state liable for any mistakes in the case. Which means if a slave master came back and said, hey, I owned him and you freed him based on false evidence, I want my slave back, the state will say no. Because the purpose of Islamic law is not to enslave people and perpetuate slavery. The purpose of Islamic law is to free people and perpetuate freedom. But because you were denied some financial benefit, you can raise a case against the state, and you can claim an injunction against the state for damages and denial of your right. Now, this is not necessarily a case, because probate law, inheritance, is something which is generally procedural. You simply apply it, right? So it's lists of laws. But almost every time the idea of inheritance law is mentioned, people will say, well, you know, I'm not sure that I want to do Islamic inheritance because the women always get less. Guess who I hear that from the most? So one of the areas that I specialize in is estate planning and inheritance. And we have a service called My Wasiyah that will give you an Islamic will, and it will be legally valid in all 50 states. mywasiyah.com if you're interested. The number one question that I get, or the number one, should I say, what's the word that I'm looking for? I'tirad, what's objection, thank you. The number one objection that I get is, well, we're not certain that we want to use Islamic inheritance because the women are going to get less. Guess who I get that from the most? The husbands whose wives have died. You know why? Because they know that their wife had a ton of gold saved up in the house, and if they say, we want to divide it according to Islamic law, then he's not going to get as much of it as he wanted. So men manipulate these issues of inheritance and the supposed injustice to women more than women do. This is my experience in dealing with inheritance cases. Because they know if they open up their wives' estates to investigation, that they're not going to be able to deny their children the rights that they have over that wealth. So if we look here, there are several instances, and what I would ask you to do is just take a screenshot of this, and there's actually an article on my website, joebradford.net, in which there's more detail than this, and I'll leave it at that. But there are instances in which a woman will take half of the total inheritance or more, so equal to the man or more. There are other instances in which she will take less than or equal to the men, one of them, but may take more than the others. And there are instances which the woman will take equal to the man. And in every single instance in which a woman takes less than the man, she has a preemptive right to maintenance from that man. So if a man dies and he leaves no one but a son and a daughter, the son takes twice what the daughter will take, a ratio of 2 to 1. Why? Because the daughter is not responsible for her own maintenance, and the son is responsible for maintaining that daughter. She has a preemptive right to be maintained and not spend from her own money. And in every single instance in which that is the case, where a man dies and he leaves a mother and a father, and so the father will get twice of what the mother gets. Why? Because the father is responsible for caring for the mother. So it's intricately tied with the idea of nafaqah and maintenance in Islamic law, which is why it's very important that when you're studying Islamic law, you do not study one issue to the exclusion of all others. But what some of our teachers used to tell us is that you can't learn Islamic law unless you learn it like you learn the alphabet. You learn from alif to ya. You learn from A to Z. If you learn 1 or 2 letters, you're not going to be able to spell anything. So you need to study it from beginning to end before you start delving into these huge issues that come up. Okay, case of adultery. This is an interesting case. So this happened during the Mamluk court. The Mamluks were around the 1500s. Okay, they are predecessors to the Ottomans. They ruled most of the Middle East. Most of the amazing architecture that you'll see in Egypt and Palestine and Sham and all these other areas, many times they're based on models that were created by the Mamluks. So there's a royal administrator in the Mamluk court in Cairo that is found necking with a woman in some hallway. They're making out, basically. Okay? So it's Club Mamluk at the royal court, right? And when he is apprehended by royal guards, the news of his apprehension goes back to the Mamluk ruler, Qatbay. Okay? So Qatbay was this Mamluk ruler that supported the memorization of the Quran, and he built wells all over the Muslim world, and but he was also an extremely violent, extremely oppressive ruler. Okay? So he hears about this royal administrator. He doesn't like him very much. He tells his guards, beat him until he admits to what he truly was doing, which was committing adultery. So they beat him until to get them to stop beating him, he admits to adultery. And so they take his admission, and they take him and they present him to the court. Now, I don't remember the name of the judge that presided over this case, but the Suyuti mentions in Al-Kawakib Al-Sa'ira, which is a work of history about the history of Cairo. And basically, he analyzes the case, and he says that it is clear in this case that there was some coercion of admission of guilt, that he was coerced to admit to guilt, because in front of me, he said, he never committed adultery, and that he was beaten, and the only reason that he said that he admitted to adultery was so that he would be exonerated, or the beating would stop. Now, if the Sharia was simply there to apply the rulings about adultery without any indication or any nuance of the circumstances, there would be no need for a court ruling. There would be no need for judges. You just basically say, this person's accused, apply the ruling. But that's not what happened here. So the prophetic principle governing issues of recanted admissions is the Prophet ﷺ's statement in a Hasan Hadith, idra'ul hududa bishubuhat, mitigate punishment through the presence of doubt. So this is the idea of reasonable doubt that we alluded to yesterday. So Islamic law contains the idea of reasonable doubt. So his recanting the admission, coupled with the method by which the admission was obtained, is sufficient doubt to say that he was not guilty. So the ruling was passed that he would remain safe in his person and property and be allowed and set free. Now, here's something that's not on the board. When he was set free, this enraged Qatbay. How dare this judge go against what I had set out as the ruling for this person? And so he wrote a letter to the judge telling him, you need to look into this case again, and you need to redecide what this case was, i.e., you need to accuse him of adultery and then execute him, because I need to get rid of him. So this was the use of religion for political manipulation. Now what did the judge do? The judge said, absolutely not. I believe in what my Prophet ﷺ said. I believe that we have to mitigate punishments because of reasonable doubt. And due to that, I will not try this case again, and I will not sentence him. When the people in Cairo heard this, they were ecstatic. Finally, somebody standing up to this oppressive ruler. They all started going to his house to learn from him and attending his lessons that he gave in some of the mosques there in Cairo, and trying to give him gifts. And this enraged the ruler even more. He sent him a letter, nailed it to the front of his door, and told him, if you do not recant, right, then something worse is going to happen. If you do not go back on your ruling, and you do not rule in the favor of the state, something worse is going to happen. He refused again. So the accused was killed and nailed to the judge's door. And then the judge was stripped of all of his titles, all of his property, and all of his possessions, and then he was exiled to Gaza. And he lived and he died in Gaza. And every year he would get a letter from the royal court saying, simply recant, simply admit that you were wrong and that this ruling was right in front of God, and you will be returned to Cairo with all of your titles, all of your possessions, and even more. And he died in Gaza, rahmatullah alayh, refusing to do so for the principle of law, because the principle of Islamic law is to mitigate any punishment. Did that man actually commit adultery? We'll never know. Why? Because of the way that that evidence was attained. And here I want to point out something. There is a chain of evidence, and there's a very detailed chain of evidence that was developed by scholars in the Muslim world for verifying things like this. And whenever that chain of evidence is broken, then that causes reasonable doubt in these cases. Now here's another issue, and this is a more modern issue. This is an issue from Saudi Arabia, okay? And this happened in the Sharia courts in Saudi Arabia. Saudi husband in 2002, a woman accused her husband of beating her and abusing her verbally. Okay, so two things. He beat her physically, he abused her verbally. She took him to court. She presented medical reports to the fact that he had done this, which showed that on the night that she claimed she was beaten, she had bruises and damage to her facial structure. Okay? So while they were in front of the judge said, "What are you accusing him of?" He heard from the plaintiff. She said, "He beat me and he cursed at me." And so the judge asked the man, "Is that true?" And he said, "Well, I only beat her and I only cursed at her because she cursed at me and made me feel bad." And so the rule of law here is وَعَاشِرُوهُنَّ بِالْمَعْرُوفِ, live with them equitably. And the principle of Islamic law is that in the face of physical evidence, a man accused of spousal abuse is guilty until proven innocent. This is one of the few issues in which innocent until proven guilty does not take effect because of the nature of the relationship. And so, based on the medical reports, the judge ruled in favor of the wife. He not only ruled in favor of the wife because of the abuse, but because of the verbal abuse that he gave to his wife as well. Now, during sentencing, the man said, "Well, you're trying to fine me for cursing her out. She cursed me out too." He said, "Well, there's a difference here. When I asked you what you did, you said, yes, I beat her, and yes, I verbally abused her. You admitted to verbal abuse. When you accused her of verbal abuse, she never admitted to it in front of me, and you never presented any evidence to the contrary." So in this case, the court ruled that he was guilty of abuse. he had to pay $9,000 of compensatory damages for his injuries and receive 30 lashes for his insulting language. Now, for the common person in Saudi Arabia, I know we have this misconception. Everybody in Saudi Arabia has an oil well in their backyard. Okay? 9,000 riyals is actually a large amount of money when you're just a common person living over there. Oh. I have no idea. I wasn't part of the process or the marriage counseling or anything like that. Public intoxication. This is another modern issue. Saudi nationals arrested in Madrid. Okay? After investigation, the Spanish authorities repatriate him to the KSA. After review of the case by several lower courts, it's referred to the appellate court. Now, he was arrested for public drunkenness, brandishing a weapon, and brawling in the street. Basically, he was in a bar, okay, in Spain, and he got into a fight, and he went out, and the fight poured over onto the street, and somebody said that he had a weapon, okay? Now, when he was pressed by the Saudi authorities, he said, well, the weapon that they claim that I have was actually a toy gun that I had bought for somebody in my family. And when they said that I drank alcoholic beverages, right, that I drank bira, right, he said, I wasn't drinking alcoholic beer, I was drinking non-alcoholic beer. For some of you, this might sound strange, but in the Muslim world, non-alcoholic beer is quite prevalent. There's Feiruz, there's Barbican, right? There's, There's, what do you call it? Aziz, yeah, there's a whole bunch of brands, right? Barbican's the best, to be honest, okay? It's an acquired taste, I know. They sell fruit-flavored ones as well, if you're not into malt drinks, okay? So he said, they're accusing me of drinking beer, but I was drinking bira, right? I wasn't drinking khamr, I wasn't drinking an intoxicating substance, I was drinking an unintoxicating or non-intoxicating substance. So when he's questioned by the general prosecutor, the appellate court found that there's no evidence or him admitting to drinking when they looked in the police reports and the court reports from Spain. But it was simply the circumstances of the case that the lower court in Saudi Arabia applied to the man. He said, oh, the Spanish said you did this, so we're going to apply it to you. But when the judge in the appellate court looked, he said, I can find no admission of guilt. And now that I've asked him, I find no admission from him. He's saying, and I have to take his word because we have no physical evidence, I find him saying that he was simply drinking non-alcoholic beer, which is very common, right? It's very common in that culture. So drinking alcoholic beverages and the use of intoxicants is forbidden under Islamic law. It's an offense that merits a prescribed punishment under Islamic law, which is flogging. Now, if you're sensitive to the issue of flogging, I advise you to read a book called In Defense of Flogging, written by a legal expert. I forget his name right now. It's an orange-covered book and it has a whip on the cover. You can't miss it, okay? It's called In Defense of Flogging. And the basic premise of it is this. If you were sentenced for some unruly conduct and somebody said, you should you have a choice. Sit in jail for 3 weeks and pay a fine, miss work, miss all of this other stuff, or we'll whip you on your back like 10 times. What are you going to choose? All right? So there's actual surveys in there asking college students about what they would choose. Most of the time they said, get it over with, right? And don't make me miss work. Anyway, here the court found that the evidence presented was insufficient to charge the accused with the crime of public intoxication. And the records that were presented were also inefficient, right? Especially in light of his repudiating the claim. So there was some doubt that was there. There was reasonable doubt. However, due to the questionable circumstances of this person being arrested and then repatriated forcibly to Saudi Arabia, the judge used his discretionary power, right, to then fine him and jail him for a certain time. To say to foreign exchange students, don't go to Spain and get caught up in a fake gun battle and a fake bar fight, right, where you're drinking non-alcoholic beer, guys. Do that for us, right? So in order to deter people from falling into that, the judge used his discretionary powers to tell people, even if you go, we're not going to allow you to go to other places, fight, so on and so forth, and then come back, because the circumstances show that something more than what you're saying was going on. We can't give you a prescribed punishment. We can't necessarily sentence you in the most severe terms, but we're going to make sure that we deter you from that act again. Now, when we talk about Islamic law and U.S. law, and I apologize, I know that the time is up. I hope that you can bear with me for a couple more minutes. When we talk about Islamic law and Islamic contract, okay, there's the idea of al-aman. And this is Ibn Qudama, rahimahullah, in Al-Mughni, one of the major books of Islamic law. He says, whoever is permitted to safely enter an opposing land, then he must not betray them financially, be disloyal to them. Being disloyal to them is forbidden. This is because they were allowed to enter with the condition that he not betray them and that he make them safe in their persons from his actions. Even if this is not explicitly stated, it is understood and meaning. It is impermissible to deceive them, as deception is not befitting of our faith, as the Prophet ﷺ says, Al-Muslimuna ala shurutihim, Muslims are to fulfill their conditions. Now this has a relevant parallel in Talmudic law, which is din de malachuta dina, right? That the law of the land is the law. So Muslims entering into another land, right? They are subjecting themselves to the laws of those lands. And so when you are a citizen that is born here, there is an implicit agreement to that. And when you migrate or travel here as a visitor, there's an implicit agreement to that. And this is something which is upheld in Islamic law. So here the question becomes, when is Islamic law applicable for us in the United States? The general principle is that anything that relies on the sovereign power of the government cannot be implemented by the individual or the community. So your jama'ah, your congregation, your masjid, your sheikh cannot say that I am the sovereign Muslim ruler here in Parsippany, New Jersey, and then start to mitigate or to mete out punishments to those people that he sees fit. This is something which can only be done by a court system underneath a sovereign state. Okay? They cannot adjudicate disputes in these things, and they can only act as arbiters. So they can't act as judges. They can only act as arbiters when arbitration is valid. When is arbitration valid? Arbitration is a contract between two consenting adults, which means that only private rights between two parties can be adjudicated. So you and I go into business together, and then we say to each other, this is not working out. We need to find a solution. We say, let's go and choose this brother here to arbitrate between us, and he'll decide. Or we choose a panel of 3 people, right? This is us creating another contract in addition to our business contract, designating an independent third party to decide what happens between us. So it can only be between private third parties, right? It excludes any public authorities and excludes anything that has to do with criminal law, legal status, or family law. So back to our pie chart on Islamic law. 65% of what we call Islamic law is inadmissible because it wouldn't be decided in a court in an Islamic land anyway. And then also anything that has to do with the rule of the courts, penal code, criminal law, international relations is inadmissible. You cannot arbitrate, the dispute between 2 countries as an individual or a community. All right? This is not, you cannot arbitrate did someone steal or not. This is completely unacceptable, and there's consensus amongst Muslim scholars that this is the case. Also, this area here, which is the idea of custody and probate, cannot be arbitrated. Why? Because probate is procedural. You simply divide it up and you go according to the rules. Custody cannot be arbitrated. A Muslim man and a Muslim woman differ about who gets custody of their child. Can they go to an arbiter, not a judge, an arbiter, a mediator, and have them decide? No, because arbitration and mediation does not apply to third parties, and your child is a third party. So you need somebody who has the force of state to be able to decide what's in the best interest of that child. And then also marriage and divorce, because marriage and divorce in Islam is not, holy matrimony forever in heaven, okay? You're not stuck with your husband or wife. There's no stigma about divorce. under Islamic law. It's a contract between two consenting adults. And so it can be mediated and it can be arbitrated. Also, your contracts, partnerships, and endowments and transactions can be as well. So, in essence, about only 15 to 20% of what we would call Islamic law, and only about 1/3 of what would be considered actual law, if we were to look at common law, would actually be applicable, and it would only be applicable when it is between two private parties that are consenting adults. So, is Islam different? And this is the point that I want to make in this slide, is that what we talked about in the beginning about fear-mongering, about Muslims and their practicing of Islamic law, their practicing of Islam as a belief system. The argument that's being made by those that have problems with Islam as a political and judicial system, and also have a problem with Muslims as a faith community, and also have a problem with Muslims simply existing, is that they want to say that Islam is different. It's somehow different than everything else. Now, freedom of speech and religion under the U.S. Constitution is not limited to people whose beliefs align fully with constitutional guarantees. Somehow different than everything else. Now, freedom of speech and religion under the U.S. Constitution is not limited to people whose beliefs align fully with constitutional guarantees. So I can say, I completely disagree with the right to bear arms. And that's still protected under the U.S. Constitution, even though the right to have right to bear arms is part and parcel of the Constitution. Now, when we look, I had Alabama up here. Alabama, Texas, Kentucky, Oklahoma, there have been anti-foreign laws that have been tried to be passed in these states. Alhamdulillah, most of them have not been able to pass. They're predicated on Islam not being a religion, but on being a political system. And they've been stricken down as unconstitutional, right, or quashed even before vote. And they're reminiscent. This happened before. This happened in the 19th century with nativist movements and with the Ku Klux Klan, where Catholicism, Catholics, were considered un-American, and their allegiance was to the Pope, and they were somehow not going to be good Americans. Okay, and it happened with the Jewish community as well before them. And it happened with the African American community before them. So there's always this group that's targeted in the United States as not being American enough, right? And it's simply our time as Muslims. But it's important that we build on what happened in the past and call attention that this happened before, and also understand the part that our faith plays in society and where it is and is not applicable in its legal sense, right? So many of the claimed intrusions into American law are actual applications of traditional American legal principles. Traditional legal American principle is the freedom of contract. And in Islam, if I want to write a contract which designates that I give my wealth in a way that is consistent with the Islamic law, then that is my freedom to do so as an American. And it has no bearing on you and your freedom to do so in any other way, shape, or form. So here's a quick quote. Take a screenshot of that. It simply shows that from as early as 1785, Muslims were a sizable enough presence in the United States to be considered mentioned by in the State Assembly of Chesterfield County, VA. And in conclusion, Sharia is all-encompassing. It is a dynamic legal system, it spans multiple continents, approaches, and centuries. Its application is dependent on time, place, and surroundings and individual circumstances. Islamic law in the United States only applies to contracts entered by consenting adults, and the shocking, hyperbolized examples are far from reality and are reminiscent of bigotry that's found in the not-too-distant past. I hope that this was beneficial for you. I apologize for going over time. Jazakumullah khairan. Wassalamu alaikum wa rahmatullah.